Thank you for joining us for the next edition of the CyberSide Chats. This is a weekly update that we'll start doing as events warranted, and this week they certainly did, as we saw some interesting enforcement from the New York Attorney General, from the Federal Trade Commission, as well as a report on breaches from the New York Attorney General that gives us some insight into what's been happening out there. The first thing of note was that the New York Attorney General did bring enforcement against three health app companies, mostly related to the alleged accuracy of the statements regarding performance of their apps, but also there was remediation required regarding privacy issues. So it's kind of important on two fronts. Here you saw the AG take issue with claims regarding the accuracy of statements and specifically regarding the performance of these apps, even though according to the New York Attorney General, that the apps were not tested to really do what the companies claimed they did. And in one case, that was an allegation regarding the app serving as a heart monitor, and the AG took particular issue with the fact that the office alleged that there was not FDA approval, it was not a medical device, and so that was at least part of the basis of the enforcement against one of these companies. There were penalties paid here, and one thing that's of particular note for those of us who watch privacy is there were remedial actions required regarding data, and specifically there was a requirement to get affirmative consent in the privacy policies of the apps to collect and share information that may be personally identifying. The AG took some pains to specify some of the data that he was concerned about, and it included GPS location, unique identifier, and quote unquote de-identified data that could be re-identified. And so what we see here is a concept under HIPAA, which is de-identification, is really the removal of 18 identifiers for personal health information. And we see here, whether the AG is using it in the classic HIPAA sense or just in a broader sense, that there is concern in that office about data that even if it's been de-identified, that it's being used in certain ways if it can be later re-identified by third parties. And so again, a civil penalty was put in here against these companies, as well as remedial action that they'll have to deal with going forward. The New York Attorney General also announced a breach report that was interesting for a variety of reasons. According to the report, there was a 60% increase in breaches from the year prior. The AG assessed that there were 1.6 million New York residents PII exposed. Probably not surprisingly, hacking was the main cause of these incidents, according to the New York Attorney General. And what was interesting is that Social Security numbers were by far and away the main thing sought by hackers. 81% of the breached information was SSNs, and financial accounts were not far behind. And that on the hacking front, hacking was a large chunk of it. And again, we have to make sure that companies are aware of kind of what the threat vectors are. And I think this is good data on the threats. What's also interesting is, despite the increase in breaches, the number of mega breaches as defined by the New York Attorney General really had decreased over the prior years. And so I think what we're seeing here is, if this data is accurate, is that more companies that are perhaps have less data are being hit, rather than simply just larger companies or companies with a large data set. So it's clear, I think, from that companies have to focus on this irrespective of their size and try to get their arms around what their cyber risk is, because the mega breaches, while they still happen, may not be the predominant source of large amounts of data for these breaches. Finally, the FTC brought further enforcement action against a company called Upromise. It stems from a prior order from 2012 regarding privacy. And in this case, the FTC alleged that Upromise, despite the prior order, didn't disclose the full nature and extent of its data collection, failed to obtain the requisite privacy assessments under the prior order. And there were additional steps that the FTC put in place, including regarding third-party assessments of new products and the imposition of a $500,000 civil penalty. That civil penalty, while probably large for Upromise, is smaller than some of the ones we've seen against other companies, but it's important to note it is a significant amount of money, I'm sure. And we also should note that what these consent decrees really do is give the FTC the ability to assess and examine companies when there is a data incident or a privacy violation, and additional FTC approvals were put in place about how data really is used by this company. So it's a very invasive at times process to go through if you're one of these companies. There was also a data deletion requirement regarding cookies, and that obviously is a barrier to this company probably using some of its old logins or using some of its old data. So it's important to note that obviously, if you're a company that has an order, that compliance with the order is something you need to be focused on. But it does also indicate that the FTC is still focused on privacy and still looking at enforcement in this space, including, obviously regarding cookies and other forms of data, and making sure that in its view that companies are disclosing the nature and extent of their data collection. So that's this week's weekly update. Really hits the highlights of what we saw this week, and look forward to doing more of these in the future.